Well, good afternoon and welcome to Papillion-La Vista High School. My name is Jason Ryan, the principal here at Monarch High. And wow, what an experience and opportunity we have here today in front of us, and most importantly for our students to experience this and to sit in on such an awesome opportunity here. I'd like to welcome the students here from Papillion-La Vista South as well. We're excited to have Titans in the building here today. Thanks for coming, and obviously the Monarchs here as well. A couple shout outs here this afternoon, excuse me. Becky Hoke, Becky's over here to my right. She is the teacher of our PLV Media Academy. We've got our media students here live streaming this event. Our students put together the microphones and set up, so just another experience and opportunity for our students to be engaged in this process. I'd also like to thank Joe Pilakowski. Mr. Pilakowski's up front here. You'll hear from him a little bit in a minute. He's our social studies teacher here who was contacted and just facilitated and organized this event, and has just did a wonderful job. I'm very grateful for Mr. Pilakowski and his time. Obviously, the State Patrol here, in their communication and coordinating all of this so we could have this here on campus in the Excellence Center. So again, an excellent opportunity here for our students to be engaged. With that, I'd like to turn it over to our superintendent, Mr. Dr. Andy Rickley. Again, we're very fortunate. Dr. Rickley, a former social studies teacher, I believe, and just near dear to his heart here to be here today. So with that, I'll turn it over to Dr. Rickley. Thank you.
Thank you very much, Jason, and happy Wednesday, everyone. It is a beautiful day, but more importantly, it is a great day to be a Monarch. We are thrilled to invite our Titan students here as well. This is a great day for the school district. Before we get a little further into the program, just a couple of other individuals that we wanted to single out. Too many dignitaries, too many really smart, important people to single them out individually, but I do want to draw your attention to the front of the room. We've got Judge Robert O'Neill, longtime school board member, longtime Sarpy County judge. He's been a friend, he's been an ally, he's been on our Board of Education. He's an outstanding individual. And his lovely wife, Carla Rupiper, who for the longest time was the city of Papillion's city attorney, recently retired, both of them. If you haven't noticed, they have a glow about them due to their retirement, no doubt. So we're incredibly pleased to have them. Interesting bit of trivia. Judge O'Neill was taught by Chief Justice Heavican. We won't embarrass the Chief Justice too much, but he was a teacher in this building from 1969 to 1971. So to have a Monarch as the Chief Justice of the Nebraska Supreme Court and a distinguished judge both come out of this building speaks so highly of this building, its staff, and this community. So Judge and Carla, thank you for being here. Seated immediately to the left of Carla is Bonnie Moore, longtime friend and supporter. She is the Chief Sarpy County Deputy Attorney. We're thrilled to have her. Jason and Joe, thank you so much for inviting us into your building. And I would be remiss if I didn't recognize my two bosses. We have at least two members of the Papillion-La Vista Community Schools Board of Education. We have Mr. Marcus Madler at the back of the room. We have Sue Ann Witt at the back of the room. Thank you for your support. Thank you for your leadership. We are so thrilled to have you here. This is an incredibly special event for our students, for our staff, for Chief Justice Heavican and his team. To have a high school host an event of this magnitude is pretty darn incredible. It doesn't happen without Joe Pilakowski and his leadership. Becky, again, thanks for you and your students picking up the baton and broadcasting this so those that couldn't be here can see this. But an incredibly proud day for the community and for the school district. Without further ado, Mr. Joe Pilakowski.
All right, thank you, Dr. Rickley. My name is Joe Pilakowski. I'm the department head here of social studies. Welcome, all of you, to this incredible experience to see the Nebraska Supreme Court. Before I begin, I want to thank two women who've worked very hard to make this day possible. First, Janet Bancroft. Janet, where are you at? Is she around here? She's over there. There's Janet. She's a public information officer for the court. Her and I shared about 40 emails about how to make this day happen, so I appreciate Janet very much. Thank you for your help. Second, Doris Huffman and the Nebraska Bar Foundation. She is the executive director, and welcome to her and those with her from the Nebraska State Bar Foundation. All right, here are some facts and decorum. about the Nebraska Supreme Court joining us today. Our Supreme Court hears oral arguments, a discussion of the facts and the law involved in the cases on appeal. Attorneys on each side will have 10 minutes to present their arguments. The side challenging a trial court or a court of appeals decision presents its arguments first with the opportunity to reserve up to 5 minutes for rebuttal. The side bringing the appeal is called the appellant. The side responding to the appeal is referred to as the appellee. The Supreme Court sits for a week-long period once per month to hear arguments and cases before them. Typically, cases are argued only in the morning. Once the oral arguments are over, the justices begin the task of deciding the cases and writing the opinions of the court that will stand as precedents for our state to follow. Court decisions are never announced from the bench. The court communicates its decisions by filing written opinions with the Office of the Clerk, the Supreme Court, and by posting them on their opinions website. Opinions are issued several months following arguments, depending on the complexity of the case and other factors. When observing the Supreme Court, it may be helpful for you to understand the various roles people around you will be playing. At the state capitol in Lincoln, where they regularly hear proceedings, the 7 justices enter the courtroom through a door directly behind the Chief Justice's chair. The newest justice enters first and is followed by the rest of the court in reverse order of seniority. The Chief Justice enters last and sits in the middle while the remaining justices alternate to his left and to his right. The newest member of the court sits on the far right as you face the bench. Today the justices will enter through the door at the front and to the right. The Nebraska Supreme Court bailiff, Miss Allie Stewart, sits at the table near the bench and will be front and your left today. It's the bailiff's duty to open the court session by calling the courtroom to order. Next, their main duty is to monitor the times which the attorneys present their arguments. As with the justices, the bailiff's duties in the courtroom during oral arguments represent a relatively small percentage of the overall work they do for the court. The attorneys scheduled to argue appeals are seated at the tables to the right and to the left of the lectern, which is located directly in front of the Chief Justice. The appellant usually sits to the left and the appellee to the right. In presenting their arguments, the attorneys speak from behind the lectern. Each attorney's time is monitored by the bailiff, and the arguments are stopped by the court at the conclusion of the allotted time. The attorney's presentations may be interrupted by questions from the justices to clarify the issues. Because of the special nature of our proceedings being at a high school in front of high school students, the court will provide the unique opportunity after hearing the case to have a Q&A session with the students asking questions of the court. Students can come up to the microphone with questions for the court, and we'll have about 30 minutes to converse with the students. When speaking to the court during our Q&A session, please refer to the court as justices or collectively as the court. Please refrain from phrases like you guys or you all. Remember, because this case has not been decided by the justices, specific questions about their feelings toward this case and other pending cases cannot be answered. Some additional rules and decorum for us. Movement within the courtroom is restricted. Individuals observing must remain in their seats at all times. When the justices enter and exit the room, the court bailiff will say, "All rise." Individuals should stand until the Chief Justice invites the audience to be seated. When the justices exit the courtroom, the bailiff will again say, "All rise," and the audience is to stand until all the justices have left the room. It is best to watch Ms. Stewart for visual clues. When she stands, the audience stands. Hopefully you do not have a phone with you, but if you do, please turn them off completely now. Silence shall be maintained at all times during the court session. No photographs or recording are allowed without the permission of the court. With the help of PLV Media, this proceeding will be broadcast live through YouTube and will be available to be accessed afterwards. With that, I will turn it over to recently retired Honorable Judge Robert O'Neill. Judge O'Neill has given countless hours of his time over the years to support Papillion-La Vista High School and its mock trial program. We are forever grateful for Judge O'Neill and all that he has given to our high school. Judge O'Neill.
Good afternoon. I'd like to thank Mr. Pilikowski and Dr. Rickley for their kind introductions. Some of the teaching staff and administrators know that I'm a proud Monarch graduate, although it was so long ago that the high school was located in what was now Papillion Middle School, and the original bond issue to construct this building was passed during my senior year. What few here at Papillion-La Vista know is that Chief Justice Heavican was a high school teacher at what was then known as Papillion High School between 1969 and 1971. The Chief Justice was my English teacher during my senior year, and in fact attended our most recent high school reunion. So it is a great honor to welcome him back to Papillion-La Vista High School today. Present are members of the Chief Justice's family, his cousin Jerry and niece Chelsea Heavican, and Jerry's wife Sue Heinrichs. Also present is Sharon Kresha, the Vice President of the Nebraska State Bar Foundation. As some of you know, the Bar Foundation works diligently on this program and runs the Nebraska State High School Mock Trial Program, along with several other programs benefiting Nebraska students. Papillion-La Vista High School has participated in mock trial since its inception over 40 years ago. If there are members of the mock trial team present, would they please stand? Give them a big hand, they work really hard. The Nebraska Supreme Court holds oral arguments at 3 high schools across the state each year. The court is particularly pleased that Papillion-La Vista High School has extended today's invitation. Also, we are honored to have them. Supreme Court proceedings are open to the public at all times, as well as those of the Nebraska Court of Appeals. That includes the permanent courtrooms at the state capitol. There are local courts here in Papillion, as well as those across the state that are also open to the public, including the district, county, and separate juvenile courts. I was one of 2 juvenile court judges here in Sarpy County for 26 years until my retirement last May. The case you will hear today is in re interest of Manuel C. and Mateo S., children under the age of 18, State of Nebraska appellee versus Amber S. appellant. Mateo and Manuel were found by the Lancaster County Separate Juvenile Court to be children who lacked proper parental care due to the faults of their mother under the Nebraska Juvenile Code. This case centers on the proper interpretation of the Indian Child Welfare Act, or ICWA. You will hear the attorneys in the court refer to ICWA throughout these proceedings. ICWA is a federal law passed in 1978 and adopted by the state of Nebraska. It allows Indian tribes to intervene in juvenile court where the children who are the subject of these juvenile proceedings are Indian children. To intervene means for the appropriate tribe to be able to participate in juvenile court as a legal party. In other words, the tribe has the same legal standing to represent its interests in the case as to the welfare of the children, as do the county attorney who represents the state of Nebraska, the guardian ad litem who is an attorney appointed to represent the best interests of the children, and the attorney for the parents. This case is an appeal from the Lancaster County Separate Juvenile Court. It is my great honor to introduce to you the Nebraska Supreme Court. With that, I invite the State Patrol to the front for the announcement.
Good afternoon and welcome to the Supreme Court. Just want to reiterate, there's a couple rules. I know most of them have been said already, but as you are aware, please remain quiet and do not ask questions during the hearing. If for whatever reason you have to leave during the arguments, please leave out the back doors. You will not be allowed to enter until the case is over. Okay? With that, this is the last chance to silence or turn off your cell phones. You don't want to be that person if it goes off. So again, welcome to the Supreme Court. We'll get started. Thank you.
All rise. Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business.
draw nigh all ye having business with this honorable court, and ye shall be heard. God save the state of Nebraska and this honorable court.
Thank you. You may be seated. Good afternoon to everyone. And thanks to everybody here at Papillion High for hosting the Supreme Court today. And we will start with introductions from the court. I am Mike Havican, and I am the Chief Justice. And now, by order of seniority, as to service on the court, the other members of the court will introduce themselves.
Good afternoon. I'm Lindsay Miller-Lerman.
William Castle, good afternoon.
Stephanie Stacy. Good afternoon.
Good afternoon. I am Jeff Funk.
I'm Jonathan Papik. Good afternoon.
And I'm John Freidenberg.
Very good. Thank you, members of the court. And we've got one case on the court's agenda this afternoon, and that is in re interest of Manuel C. And counsel, each side has 15 minutes to argue this morning. Is it Ms. Clabundi? Good morning to, or good afternoon to you. And Ms. Lamsky, good afternoon to you. Do either counsel have any questions before we begin? Then, Ms. Clabundi, you may approach the podium and you may proceed.
Chief Justice, Your Honors, Counsel, may it please the court, my name is Jacinta Clabundi, and I am an attorney with Legal Aid of Nebraska, and I represent the appellant, Ms. Amber S., in the case before the court this afternoon. I would like to save 2 minutes of my time for rebuttal. Your Honors, this case is about the best interest of Manuel C. and Mateo S., the children in this case. This case is also about the sovereign right of the children's tribe, the Red Lake Band of Chippewa Indians, to determine their members and lend their knowledge and expertise to the work being done in the juvenile court below on the children's behalf. The Indian Child Welfare Act, also known as ICWA, and its Nebraska counterpart were enacted to protect the best interest of Indian children and to promote the stability and security of Indian tribes and families. The best interest of Indian children is part and parcel with the compliance with ICWA. The juvenile court orders holding that ICWA and NICWA did not apply to this case and denying the Red Lake Band's request to intervene fundamentally ignore the sovereign and exclusive right of the Red Lake Band to determine its own members and is contrary to ICWA, and it is not in the best interest of the children in this case.
Has the membership status of anyone involved in this case changed since the case was briefed?
Not to my understanding. It's my understanding that the tribe has accepted and referred the children and my client, the appellant, for enrollment, but I don't believe that the official enrollment has occurred, but they still do say that my client and her children are members, as was included in their brief as well.
I think that you made reference to some provisions in the regulations, is that right? The 25 CFR regulations as to who gets to decide.
Yes.
Could you expand on that, please?
Yes, I could. In regards to the section that you are talking about, I believe that section states that the tribe has the sovereign right and their determination that a parent or a child involved in a juvenile court proceeding is a member of that tribe and is conclusive and must be recognized by a state court, and that the tribe has the sovereign authority to determine who are members, including different classifications of membership. And once a tribe provides that information, that it has determined that the children are members, a state court must accept the tribe's determination as conclusive.
I beg your pardon, so is there some tension between the federal regulation and the state application of ICWA?
Yeah, I think there is some tension, but I believe that in the plain language of the ICWA statutes, it does not speak to any enrollment. It does not speak to them being tied together. What it speaks to is Indian members or children who are eligible for membership and the parent, and the child of a parent who is a member.
How does the tribe determine membership?
I think that every tribe determines membership differently.
What's our evidence in the record about how this tribe determines membership in this case?
I think that the evidence in the record says that, in regards to that, I'm not quite, what I would say is that the tribe determines membership. I
Because
don't think it matters.
there's some cases where courts will say enrollment is not the only method by which someone may be a member of a tribe, because some tribes might not have roles. They have different ways of determining membership. So do we have anything in our record that tells us how this tribe determines membership?
I think in the record, they state their descendancy laws as well as other means, and I think that you can look to the record to see that. But I also think that the tribe has determined that they are members, and I think that they speak to that in their representative testifying. I also think that they speak to that in their motion to intervene, and I think they speak to that
Well,
between the
intervening, would you
correspondence.
concede that intervening alone isn't enough? There also has to be proof of membership.
I think that a tribe, I think from the actual regulations, that a tribe can relay and say that this person is a member, and then if they state that person or child is a member, then it must be determinative. I think that the case law in it and other jurisdictions as well supports that. I think that one of the things that one of the cases is in readoption of Riffle, where the Supreme Court of Montana found that enrollment of the Indian child was not required, so long as the tribe recognized the child as a member. And they also concluded that enrollment and membership are not synonymous, and that the Turtle Mountain Band of Chippewa Indians' determination that the child was an Indian child was conclusive. And I think here it's clear what the tribe is saying. I think they're saying.
Is there a difference between membership in the tribe and membership for the purposes of ICWA?
I think that they're one and the same. I think but every single tribe has a different membership. Every single tribe is different. And if Congress intended to tie enrollment to that, then they would have put that in the statutes. But they have refused to and have not done that in hundreds of treaties with tribes. And so I think that they are leaving that sovereign part to the tribes, because they are each their own nation, their own sovereign nation, and so they get to decide that. And so I think here the tribe is saying to the lower court, and also in their appeal and their cross appeal to this court, that they consider my client, the appellant, and her children to be members. And I don't think that is disputed.
How does that square with your suggestion earlier that the membership process was still going on?
So I think that it's an enrollment process, and I don't think, like I said, enrollment and membership are not synonymous.
Didn't the tribal representative testify directly to the contrary? Wasn't the tribal representative asked, is there any difference between an enrolled member and a member? And didn't the tribal representative say, same thing?
I think that the representative also testified that they consider my client and her children to be members of the tribe for the purposes of the protections of ICWA. And I think if you look at it at the whole, that both the tribal representative's testimony, as well as the motion to intervene, as well as that correspondence between the tribe's council and the Lancaster County Deputy Attorney, as well as the cross appeal, all says, hey, overall, we believe that my client and her children are Indian members. That is what our position is, and that should be taken as determinative and conclusive, because that's what they are saying.
Is there at least the potential for more than one classification of membership within this particular tribe? In other words, is it possible that the tribe may say, yes, they're members for purposes of ICWA, but not for purposes of fill in the blank?
Yes, I do think so, and I also think that case law supports that I believe in the Court of Appeals in the matter of NCH from the Oregon Court of Appeals, it relays that in 25 U.S. Section 1903, subsection 4, it does not distinguish between or among tribal memberships, and there's no provided plausible basis for treating one class of tribal membership differently from another, and that the ICWA does not grant courts the latitude to determine that some types of tribal membership qualify children as Indian children and others do not. And so if you have those different memberships and the tribe is saying, we have determined they're Indian members, regardless of what type of Indian member they are, as long as they are saying they are members, I believe that's determinative and conclusive under the federal statutes as well as the state ones.
Is it possible, I'm not saying on this record what it is it possible that in some tribes and in some instances, the tribe could say these children are Indian children for purposes of ICWA, but these other children are not, even though in all other respects they might be the same?
I think that they determine their membership and they get to speak on it. And so if they made a determination that one child was an Indian member, then that is their determination. If they decided another child was not an Indian member, that is also their decision as a sovereign government.
Does the record tell us anything about when this tribe determined that these children were Indian members for purposes of ICWA?
I believe that they were Indian members as soon as the tribe found out that this case was occurring. They immediately contacted the county attorney as well as the department. I believe that they were Indian children as soon as they relayed that they are members of their tribe.
So I guess my question, though, is theoretically or hypothetically, could a tribe not recognize a particular child as an Indian child for purposes of ICWA unless and until some sort of action is filed in a state court and then change their mind?
I don't think I've ever seen a case where they change their mind that someone is an Indian child.
So does the timing make any difference?
I am unsure on that.
All right.
I think that this tribe is stating that they are members, that they have a descendancy through their tribe, and that it was a separate case that caused the severance and caused them to make it so that they didn't have that connection. And they're trying to repair that connection, and they believe that my client and her children are members, and I believe that that is a conclusive determination. I believe from all of the evidence, it is clear what the tribe's position is. And so I do believe it's conclusive that it is an Indian child. And in the alternative, if there is any question if the children are Indian children, then it should go back and be reversed and remanded to conduct a further evidentiary hearing to determine if the children in this case are Indian children.
Forgive me for backing up here, and this is not mundane, I think. There's been a question, there's a challenge here to appealability of this order?
I believe so.
Could you speak to that, please?
I'm sorry, what?
Could you speak to that?
Yes, in regards
Thank
to
you.
whether this is a final appealable order, I do believe that it is. We would respectfully disagree with the state's position. We do believe that an order denying a tribe's motion to intervene is basically intertwined with the denial of ICWA, and we submit that ICWA actually creates a substantial right under state and federal law, and denying that it's applied to the case makes it so it affects my client's substantial right. And I believe that the state appellee relies on in re interest of Jasenia H., and there's a substantial difference between that case and the present one before the court. I would also state that in re Jasentia was decided before the updated federal regulations from 2016, which changed it and made it so that as soon as there's reason to know an Indian child is involved, ICWA should be applied until it is on the record decided that ICWA does not apply.
Can you cite us to any cases that would help us determine that?
I'm sorry, what?
Can you cite us to any cases that would help us determine that jurisdictional issue?
I believe that some of those cases are included in my reply brief, as well as in the amicus brief that was filed by Appleseed. I don't know if I can point to any particular cases now, but I do believe they are included in the briefs.
What's our standard of review for the district court's determination of tribal membership?
I'm unsure. I think that, again, it should be a very low bar. It shouldn't be very hard or overcomplicated to decide if a child is an Indian child. We want tribes to participate when they are Indian children. And
I guess what I'm getting at is, is the trial court owed any deference to the extent this was based on in-person testimony and possible credibility determinations?
I don't believe so. I believe that's because the federal laws also preempt this, and I believe that it is clear that the federal laws were that the tribe is supposed to be conclusive and determinative, and that the state court cannot supplant its own determination, and that is essentially what the state court is doing here. They are tying, in the order, it ties enrollment all over to membership. And that is not the case. In multiple cases that were cited in the briefs, enrollment is not synonymous. If we did so, that would make it so that all tribes are homogeneous, and they're not. They are their own governments. They get to decide who is their members, just as the United States gets to decide that.
Excuse me if you're interrupting. Let me ask you another hypothetical question. Just assuming perhaps that we did not decide with you, and we decided that enrollment was necessary, could you bring, also assuming at some point in time that mom is enrolled and so that further hurdle has been taken care of, could you bring an ICWA action at that point in time, even if the case had progressed considerably down the line?
Potentially, but I think it would go directly against tribal sovereignty to decide their membership and require that enrollment is tied to it. I think that would make it so it was extremely difficult for tribes and also create issues with challenging all of tribal enrollment. And I see I have 10 seconds left. I would like to reserve it for rebuttal.
Thank you very much. Ms. Lamsky, good afternoon to you again. You may approach and you may proceed.
Chief Justice, Justices, my name is Maureen Lamsky and I'm a Deputy County Attorney and I'm the appellee on this matter representing Lancaster County, State of Nebraska. And in this case, I believe Justice Miller-Lehrman asked the question about whether there's been any changes. We've had numerous hearings on this in a related matter as far as that, and I believe that by the time there is an opinion issued by this court, it will likely be moot as to this case, as there will be that determination as facts have progressed. I would, though, ask that the court find that.
So are you saying the termination will have been completed at that point in time?
No, what I'm saying is that the enrollment process, the tribe's enrollment process, they've now done the genetic testing, they've had their various board meetings, and they're just waiting for one more meeting, is my understanding, that's supposed to happen in the next 30 days.
So you're suggesting this might be moot, and what ultimately are you suggesting about what this court should do?
I don't know, because normally if there's a suggestion of mootness, there's a document to file, but I don't have that at this point. I just.
And that's because you're not yet in the position
to
file.
say it's moot because we don't have the enrollment documentation. I would argue, though, that the court is without jurisdiction in this matter because it's not a final appealable order. I think the lower court, the separate juvenile court, could have went on and done the TPR, and this issue could have been raised in that as far as the standard and everything there.
Aren't the denials of motions to intervene generally final appealable orders under our precedent?
Well, and then again, this is not the tribe that is appealing this. This is the mother's attorney that's appealing this.
Tribe filed a cross appeal.
And then I guess that could be, but that could have been, it still could have been addressed because if there was error at the time of the TPR,
That's true of any intervention case though, right? The the case could continue on to the end, and the intervention could be reviewed at final judgment.
Yeah, in this case, it's detrimental. The length of the appeal is detrimental and has pretty much made everything moot at this point, because for the children, and under ICWA, that is not done for the best interest of the children, as Ms. Dyke-Bundy stated. It's done for the best interest of the tribes and them wanting to protect the resources and to correct the wrong that was done
I think
in the
she
past.
suggested it was in the best interest of tribal children.
I don't think ICWA is in the best interest of tribal children in all cases. These children, this case had been going on for an extended period of time, and there would have been the TPR already completed before the state had any clue that this was going to be ICWA, but for continuance due to a vacation I went on.
But we
So
don't get to decide
we don't
that.
get to decide that, I know. So I don't think it is because it's upending that permanency, and as the court is well aware of, the need for permanency after, well, at this point is over 2 years, for children such as young as these children are, it's imperative. And because this is an ICWA case, well, it will be an ICWA case, it's not at this point. And the main issue that the state's position was that it wasn't an ICWA case then was because the
Well,
tribe.
what have we said about appealability from ICWA cases or ICWA issues thus far? And what is the reason why, I guess I might suggest that our appealability from juvenile cases is a little more open and lenient than in other cases?
I guess I'm not understanding what I'm
Well,
supposed to.
I asked you two questions.
Okay.
What have we said about ICWA appealability, ICWA issues, not necessarily this issue, but ICWA issues in the past? Have we said you can't appeal those at this point in the process, or have we accepted those appeals?
Those, well, I'm trying to think of a specific appeal right now. And the standard that mostly comes to the one is that the best interest isn't applicable in deciding whether or not to transfer an appeal or to transfer a case to the tribe. That wasn't necessarily on intervention. So I'm not
Brittany
Sure.
C. was a transfer case, wasn't it?
that to transfer it, yes. And I know that those do get appealed, but that's usually the tribe has already intervened by the time they're asking to transfer. And this is kind of a unique situation. In the decade I've been in juvenile law, there's never been an issue or fight about whether or not it is ICWA. And the reason that there was in this case is because usually tribes will say this person is a member. But here, from the very beginning, when we'd ask if the mother was a member, it was a member for purposes of ICWA.
Is that a thing?
No, you're either a member or you're not. And that was what was frustrating. We would
Did your office change positions on this?
What, I'm sorry?
Didn't your office change positions on this case?
I don't think so. We've clearly said from the beginning, we didn't think this was ICWA. I know the court did initially make that finding, and that, I think, was just based on the form where there were no positions on that. And it just says that they were eligible, both mother and child.
Is that enough?
No,
Both
because,
eligible?
and I don't, looking more at those forms, because the question whether ICWA applies is two-pronged. The first question is the parent enrolled, or is the parent a member? And the answer to this was always no. They just wanted to extend the membership, and the Bureau of Indian Affairs in their rules, which was offered as an exhibit, clearly states that tribes, they get to determine who's their membership, but they don't get to claim children.
What's that mean?
Well, to me, it means you can't say, well, you're just going to be a member for ICWA, so we can take over this case, and then we'll figure out whether or not you're a membership later. I think this is probably the best example of a tribe trying to claim children before they've done all their own processes. And it is the tribe's determination to do their process of enrollment or their process of membership. But the state of Nebraska and these children shouldn't have to be like, well, we'll just give you ICWA determinations, and then, you know, if the genetic testing turns out differently or something, we'll change our minds. I think they have to either say, these children are members or they're not, and they wouldn't say that. They would just say, no, they're not, the mother is not enrolled, the children are not enrolled. We believe they will be eligible to be enrolled, and so we're extending ICWA to them. We're extending the protections of ICWA. And I don't think that's allowed under federal ICWA or state ICWA. I don't think their sovereignty gives them a right to extend membership for the purposes of ICWA. And that's why I think the lower court decided the decision correctly and found that ICWA did not apply at that point. ICWA is clearly prospective.
Excuse me, so I'm trying to follow the logic of that. So if the tribe's position is that the child's eligible, then treat this like a citizen member.
Well, but for the child to be eligible, you have to answer the first question, is the parent a member? And they never would say that she was never an enrolled member.
Right.
And when you asked, it was membership for purposes of ICWA, or membership, we want to extend the protections of ICWA to her. They don't get to extend ICWA. And since you couldn't get past the enrolled, it can't just be
You
a
couldn't
child.
get past it with mom, so you
So you
never
can't-
went on to children.
Yes.
Okay,
So
thank
it
you.
can't be just the child is eligible, it has to be the parent is enrolled and the child is eligible.
Your position is not that enrollment is everything, correct?
No, because I think there are different tribes that could not have enrollment, they could just say membership. The problem in this case is that they're not saying they're members of the tribe, they're saying they're members for purposes of ICWA.
And we don't have anything in our record about what the requirements of membership are.
No, and I mean, they
And
clearly.
Whose burden was that?
Well, that's their burden. I think there's a case law in that that's cited in my brief that says it is their burden to prove that. And it was pretty clear that the other portions of the tribe that decide membership were still deciding that issue. But in the meantime, they just wanted to extend the benefits, and I think that was improper, and that's why ICWA does not apply at this time.
So
this
it's
case.
evolving, right, and your position is it was a correct ruling at the time it was made?
Yes, it was definitely a correct ruling at the time it was made.
Could it be reviewed later by the juvenile court?
Well, I mean, it's a prospective determination. You can find ICWA at any point if it changes, because the tribe can change their enrollment guidelines. They've had that before where a child isn't eligible because the blood quantum isn't met, but then if the tribe meets to convene and changes the blood quantum, then 5 years later, child could be an Indian child. That's a different scenario, so it's always prospective, and then from that point going forward.
So, but in this case, the juvenile court determined ICWA did not apply, but could that juvenile court make that decision in this same case at a later time?
Well, yeah, after the enrollment process is done, or after after the tribe says, this child, Amber is a member, unequivocally without for purposes only of ICWA, then I think they could come back again at any time. And that's why it's not really a final appealable order, because they can come back and revisit that issue once the mother is a member.
So if we were to find that your position is correct, it would be important that we make clear in the opinion, we're only speaking as to the determination that was previously made, and it has no preclusive effect on future changes.
So that
would
gets me
agree with
back
that.
to at that point in time,
Yeah.
you think it was a correct ruling?
Definitely.
But if that were so, and this court were to agree, but the underlying case moves along, does termination move along?
Well, I don't know, because
Is this a timing thing?
well, it kind of depends on what happens next. I think the court has to get jurisdiction again, and I would want to move forward, but then there's the whole issue of case transfer, what happens, which kind of makes the case tough and sad for me. But yeah, I mean, that's how it would work
So
under the
can you
current law.
have
It's,
Is there such a thing as an ICWA determination after termination has been decided?
I think you could do that too, yes.
And what's the practical effect of that?
Well, I think there would still need to be like the cultural plan, and things like that going forward. But then that child still, I mean, the whole purpose of ICWA is to make their efforts that the child still has a relationship and.
With the tribe.
With the tribe, yeah.
Not necessarily the parent.
Yeah, I mean, because you can still do a TPR on an Indian child. It's been done before.
It deals with placement, things of that nature, where you'd place the child.
But yes,
that correct?
potentially, yes, it could deal with that, yes.
So an ICWA, a determination, ICWA always applied after termination. I'm moving along. Next steps are incorporate the cultural features and so forth.
That would likely be what would be the main thing is, yes. But I mean, that's not something that most people are against trying to do that part, but yes, that would be the next step.
But you're telling us today as an officer of this court that in all likelihood, by the time an opinion would come out, even an expedited opinion, there very well could be some obligation that you might have to suggest mootness.
Yeah, yes, likely. I mean, can't say that for sure because it hasn't happened yet. It's based on what I've been told, it's a high possibility, but I don't know. So, again, my main position is that at the time that the hearing was held, there was no, the court was correct in finding that ICWA did not apply because the tribe cannot say somebody's a member for purposes of ICWA and not be a full member. And with that, I would ask the court to affirm the lower court. Thank you.
Thank you very much. Do we have time for rebuttal?
7 seconds, Your Honor.
7 seconds. We will actually give you 2 minutes, Ms. Diclabundi.
Thank you, Your Honor. I would first like to address that what the state's position is, stating that it's on the tribe and on the person trying to prove ICWA to show that it applies. I think the updated federal regulations and guidelines make it so that it is on the person objecting to the ICWA being applied to disprove that it should not apply, and they have to prove
And
due
how
diligence.
binding are those regulations on, in this case, the juvenile court?
I think the federal regulations are binding, and I think that the Court of Appeals in Nebraska has looked to the BII guidelines as something that they should take deference to, and so I do think that they've done that in court cases in the past. And so I do think that that is something that should have been applied, and I think here that there was not enough time or due diligence if there's any question. But I think that the overall what is being argued here is that if these are Indian children or not, and I think the tribe is very clear on their position in that. And I think they have done that cross appeal to show their position. I also would like to address the mootness that the state did mention. I do believe that even if my client and her children are officially enrolled with the tribe, that this should still be decided for under the public interest doctrine. I think it's important to clarify that tribes' deference to them and what they are saying in regards to membership should be given full faith and credit. And so I do believe that that is something that should be done. I would also say that it is in the best interest, as I said earlier, to have ICWA apply for Indian children. Congress has stated that in the ICWA regulations that the best interest of Indian children is part and parcel with ICWA.
Before you sit down, you heard your opposing counsel suggest that the record shows that the tribe has never said that these children are members. They've merely said members for purposes of ICWA. Is that an accurate characterization of the record?
I disagree. I think the record, as stated before, the representative said that they considered the members, regardless if they said purposes of ICWA or not, they considered them members. I think that the correspondence between the tribe's council and the Lancaster County Deputy Attorney also says we consider her a member for the purposes of ICWA.
Well,
It doesn't matter the
for-
classification.
That for purposes of ICWA seems to be what your opposing counsel is saying, that's what the record is saying. Is that what the record says?
I think that it says they're members, and I again, would say that by cross-appealing, they have stated that they believe they are members.
Is there ever an assertion in the record that they are members, stop?
I think that, again, their cross-appeal makes that clear. They
Is
are
there
members.
ever an assertion in the record, evidence in the record, that they are members, full stop?
I, again, would say that she testified, and I would say that if there is any question, that should have been given more due diligence and should have been looked to and should have been, further evidence should have been presented. If there's any question, I think the federal regulations are clear that you have to do due diligence and work with the tribe to ensure that this child is an Indian child. And I don't think on the record any due diligence was done if there was any question. And I think that the order shows that that the lower court tied enrollment to every portion of ICWA. Thank you, Your Honors.
Thank you very much, counsel. That concludes arguments in re interest of Manuel C. And hence you are excused, but you can stay around. The court is now adjourned, but what we do at this point is we take questions from high school students and/or other parties in the audience today. So I will ask you to refrain from doing a couple of things. First of all, we cannot discuss this case or the details of this case, so please don't ask questions about this particular case. And my other request to you is please don't, when you're asking a question or making a comment, please do not refer to the court as you guys. And there are a couple of reasons for that, but it happens all the time. Obviously, we're not all guys, and beyond that, that's pretty informal, and we love you, but we're not quite that informal. So please try not to refer to us as you guys. I made that request of the students at Creighton this morning, and somebody referred to us as you guys. So with that, please raise your hand with questions. And you can actually come up to the podium so people can hear, but you don't have to come up to the podium. And don't be bashful.
But it's fun to come.
Here we go, we've got a question
Right, you have a long
on the way.
Hello. My question for the justices here today is, what advice do you on the court have for young people who are interested in pursuing law?
Very good question, and I think you all heard that, but the question is, what advice do we have to young people who might want to pursue a career in the law? Anybody?
Go for it. There is no particular undergraduate degree that you need to be admitted to law school. So when you're picking your undergraduate degree, pick whatever you love, right? Wherever your true interest lies. I was in law school with people who had music degrees. The Chief Justice was an English teacher before he went to law school. Isn't that right?
That's correct.
Where was that at?
So you can get a teaching degree as your undergraduate degree, you can get a science, you can get math, you can get whatever you want as your undergraduate degree, and then go on to law school. While you're in high school, do as much as you can. Get on the debate team, test your mind, stretch your mind, test your public speaking, right? Speak under a whole lot of different circumstances. What you're doing right now, A+, right? You walked right up to the podium and you asked a question. That's good practice.
Thank you, Your Honor.
There are mock trial programs that you can get involved in that are fabulous, and you can go on and do the same thing in college. and go up against other colleges and compete there. All of those things will help hone your skills in the law. So those are just some things. You'll get some good suggestions from other folks too.
I'm not so much in the suggestion pigeonhole, but I just comment that one of my law clerks was a theater major, and she was very good at oral argument in her subsequent career.
Well, thank you, Your Honors.
Thank you very much. Who's up next? Yes.
Hello, Your Honors. My name is Gavin, and my question is, how do you guys prepare for cases?
How do we prepare for cases? Anybody?
It's a lot. It's a
Don't
lot
be
of.
bashful.
It's a lot of reading. So almost all of the cases that we get, including the case that you just heard today, are coming from another court. We're reviewing the decisions of another court, and rather than having all the witnesses and if there's a jury and everybody come back and retry the case, it's all taken down on paper. The testimony is taken down. The documents that are exhibits are compiled, and they come to us in big boxes, and we read everything that happened in the trial court, and then the attorneys get the chance to make arguments to us in briefs, and so that's more reading, and then we'll prepare memos for each other to review, and we may do research on the laws, which may require us to read statutes or prior cases, or like in this case, regulations, and what we're doing is we're looking at what the appellant has alleged, what mistake the appellant has alleged that the lower court made, and we're looking at the law and seeing if the lower court correctly applied the law to the facts. So almost all of our preparation is reading, but it's reading a lot of different materials and a lot of different stuff.
So the obvious lesson today is, and you all will be smarter than the average person on the street, is to know the difference between what happens at the trial court and what happens here at the appellate court. We don't rerun the trial and see who was telling the truth, right? It's been funneled up to us.
Sorry for referring to you guys as that. I didn't realize. Again, I did it.
You
I'm
caught
sorry,
it.
Justices.
Thank you very much.
You're very brave. Thank you.
Thank you.
I've told the Chief Justice a number of times, I think we're losing that battle.
Very good. Okay, who's next? Yes.
I would like to ask the court what the most difficult part of earning your degree or major and becoming a member of the Nebraska Supreme Court was.
And I will rephrase that as, what was the most difficult part of getting through law school and getting through the profession to the Supreme Court? How about that?
Mm-hmm.
Good. Anybody?
I think like all jobs, there's good and bad parts of your job. And when you're going through the bad parts, the parts that are hard, and you've worked really hard on a case back as an attorney, and you put all the blood, sweat, and tears into it, and then you're unsuccessful, and you have to have that long conversation with your client, those are really hard times. And then when you do, on the opposite side of it, those are really good times. But I believe those are the same type of thing you're going to face in anything you choose to do in life. So what we're doing is anything easier or harder than anybody else. It just happens to be specific for our profession. So it's basically the hardest part is always getting through the tough times and whatever you choose to do.
Thank you, Your Honor.
Thank you very much. Yes, sir.
Good afternoon.
You're one of our bailiffs.
Good afternoon,
Good job.
Justices. Thank you, thank you. I had a question for you justices. What influenced you all to get involved with the law?
Very good. What influenced us to get involved with the law?
Well, I'll start. It was the family business. My father was a lawyer, and when I left the University of Nebraska Law School 40-some-odd years ago, I headed home to practice with him, and I thought that's what I would be doing the rest of my career. Since then, I've been a district court judge, a court of appeals judge, and now on the Supreme Court. So obviously, life took me in some different paths than I anticipated. But that's how it started, in the family business.
I was fortunate enough to have a neighbor that was a county attorney and then a judge. He took a liking to me and kind of directed me on a path of how I should move forward in college and law school and then the practice of law. So I would suggest that if you have interest in the law, you reach out to people like us or judges in your community or lawyers and ask them if you could follow them or job shadow them and see if it's something that you enjoy. And if you do, those people can be very important mentors and just kind of help you with the steps you got to do and things that you should avoid doing and be invaluable, I think, to move your goals forward. So.
When I was in high school, I met with my guidance counselor, and back in the late 70s, when you met with your guidance counselor, there was a whole stack of cards that you went through with different occupations on them, and they broke them down into little traits of that job. And you would look at it and you'd say, does that sound like something I like? If so, it goes in this pile. If it doesn't sound interesting to you, it goes in that pile. And I did that little exercise, and my guidance counselor told me that I really ought not go into the law. And that I was probably better suited for something like forestry, to be a park ranger. She thought I had perfect skills for that. So I guess I tell the story to say they're not always right when you do the testing, and you should probably follow your interests.
I'm gonna tell you a story, but I'll make it the executive version because it's a little similar to Justice Stacy. I was already interested in the law when I was in college. I am not a good test taker. I had good grades and poor LSATs. Those are the tests you take to get into law school. And in those days, you would go for an interview to get into law school. And here's the part where I'll name names because this is a public story. So, and I grew up in California, so I went to Stanford Law School, and they said to me, don't bother to apply, you have no aptitude for the law. But we ignored that. We ignored that, and here I am. And in the practice, at some point before I went on the bench, I was hired by Stanford to represent them in a case, and I did it at trial, and I did it at the Court of Appeals, and they thanked me for it, and the lady who was the inside counsel said, oh, how can we possibly thank you? I think, oh, now comes the time for the and it gets better. There's more, right? And I said, here's how it unfolded, but evidently I do have an aptitude for this line of work. And she was like, OMG, my husband is the dean of the law school. I got a bouquet.
Very good.
Thank you, Justices, for your time.
Thank you very much. Who's up next? Yes, sir.
Clear back there. Oh, got another one.
There we go. So what do you think has been the most interesting part of getting to be on the Supreme Court of the state of Nebraska?
What has been the most interesting part of being on the Supreme Court of the state of Nebraska? Anybody?
Well, one interesting part is the variety of kind of cases we get. So any kind of case that starts in a state court in Nebraska, almost any kind of case, could make its way up to us. And so because of that, there's just a huge variety in the kind of cases we get. So it would not be uncommon for us to have a day where we might have a criminal law case involving everything ranging from assault and theft to homicide to business disputes, divorces, child custody disputes, breaches of contract, personal injury, all the kind of things that you can imagine that people might have disputes about can make their way to us. And so it's always different kinds of cases and always new and interesting facts for us to encounter.
To build on what others have said, we see all of that human drama, but most of the time we don't see the actual drama. We see the after effects of the drama, but we're all cognizant of the real people, the real parties, the real children, the real victims, the real participants that we typically do not see. We normally see the lawyers who are here arguing the case at the final stage. But there's still that human drama that's a big part of the story.
Thank you very much.
Thank you very much. Who's up next? Okay, we've got a case, the young lady way in the back.
Hello, Your Honors. Why does the Supreme Court come to high schools to do cases like these instead of a courtroom?
Question, why does the Supreme Court come to high schools like this? Because that's our favorite part of the job. We come to high schools like this. We started doing this about 10 years ago, and we try to do it 3 times a year. When we have long before any of us were on the court, the Supreme Court has always gone to the 2 law schools here in Nebraska to have oral argument sessions there once a year. Once a year to Creighton, once a year to the University of Nebraska at Lincoln. And about 10 years ago, when we came to the session at Creighton University, we decided that that would be a good opportunity to visit a high school because we want folks to understand the judiciary, the importance of the judiciary in any democracy, and especially in our democracy, and to the folks of Nebraska. And so it's part of the court has a lot of responsibilities, and one of them isn't directly to educate the public, but we especially want young people to have a civic understanding of court systems and how they work. We went to Central High 10 years ago, and that was approximately at the time of the 150th anniversary of the state of Nebraska statehood. And as you all know, Omaha was originally the capital, and where Central High sits is Capitol Hill. And so the Nebraska Supreme Court originally sat at that location in Omaha, Nebraska, before the capital was moved to Lincoln. So that was our first visit to a high school, and since then we've expanded that. We visit one metro area high school when we come to Creighton, and once a year we try to go somewhere into the vast reaches of greater Nebraska. Last year we went to McCook, we've been to Scotts Bluff, and we also, earlier in the fall, we try to go to some place in greater Nebraska that is not as far as Scotts Bluff. So we've been to Nebraska City and Beatrice and so forth. But it's part of a bigger opportunity that we want young people to understand the courts, and we want old people to understand the courts too.
Thank you, Your Honors. Thank you.
Thank you. Yes, we've got another hand back here.
Hello, Your Honors. Let me ask, sorry. What impact has this occupation had on your social lives? And was any of it like significant to you when you were first starting your education journey?
What impact has being on the court or being a judge had to our social life?
What social life?
Anybody?
What social life is pretty much.
You have to have a social life beforehand to have an impact.
Yeah, get that out of the way.
You do have to be obviously a little cognizant of the things that you do. We have a responsibility as judges not to put the judiciary in a bad light. So if we're out doing something in the public that would not look good for the judiciary, then we shouldn't be doing that. So even before we got to the Supreme Court, all judges sitting have thought about that and what it looks like to the public. The public has to have confidence in the judiciary. You have to feel comfortable that the people that are sitting in these positions are people you want to be sitting here, and that their decisions are going to be made on the right factors. If we're out doing something crazy in the public, you're probably going to lose some confidence in our decision-making. So those are things that I think we all have to take into consideration. We also have to be fair and impartial. You want to have confidence when you come to have a case heard before us that we aren't going to side with somebody because we spend Friday nights playing poker with them or something of that nature. You want us to be fair and impartial. So those decisions weigh into our social life. We won't usually go out and hang out with lawyers because they may come before us, and then if somebody isn't in that group, may think, well, we're biased towards them because they weren't with us in the social activity. So we try to be very careful what we do and how we do it, and so it does impact our social life.
Thank you.
Thank you very much. Anybody else? We've got a question over here. Again, from one of our bailiffs. Thank you very much.
I enjoyed the experience. Can I ask the court, so I know we touched on backgrounds and possibly a little bit on the majors. Can I ask specifically what each member of the court majored in before law school?
Here you go.
History.
Criminal justice and political science.
Political science.
English.
Started in journalism and then changed to accounting.
I was accounting as well.
I started in engineering, ended up in law, so I ended up with math and criminal justice.
Thank you.
Thank you.
Thank you. Anybody else? We have time for probably one more question. Okay.
I'm just going to ask how you decide which cases you hear.
Very good. How do we decide which cases that we hear? Well, there are some cases that we have to take by statute or other authority, and those would be on the criminal side of the docket. We have to take life imprisonment cases and death penalty cases, and we are supposed to take cases that have constitutional issues in them, and that can get a little fuzzy and gray, but it is the responsibility of the lawyers who represent a particular side of a case to point out constitutional issues if there are constitutional issues in a case, particularly if they are asking that a statute be declared unconstitutional, and part of that process is they're supposed to notify the Nebraska Attorney General's office, so that office has the opportunity to intervene and protect the constitutionality of a statute, if you will. We try to fill out our docket with cases that we think are of particular importance to the people of Nebraska and/or cases of first impression on interpreting a statute in the state. All of this that I'm blathering about, you should have the background information that there is a court of appeals in Nebraska too, an intermediate court of appeals. So the way appeals happen, they come from the trial courts, and each county in Nebraska has a county seat with a county court and a district court, and those appeals then, the unhappy party gets to appeal, and that appeal might, if it isn't one of the topics I've just touched on, that appeal likely will stay with the Court of Appeals and not come directly to us. But if you don't like what happened in the Court of Appeals, you can ask us to review what happened in the Court of Appeals. So pretty much in Nebraska, you've got a right to appeal darn near anything, and then those cases I talked about come to us, and others may stop at the Court of Appeals. Okay, that's kind of a wrap. Do we have one more question back there? We'll take one more.
Hello, Hello, my name is Adrian Zook. How does one get into a place in their career that they can join the Nebraska Supreme Court?
Good question. How does one get to the point in their career that they can join the Nebraska Supreme Court? Anybody? Did anybody go through this process?
Well, all judges in Nebraska at whatever level go through the same sort of process that begins with practicing law as a lawyer and then applying for an open position after someone has retired, resigned, or died. And then there is a local nominating commission that considers the applicants for that vacancy. It's a little more complicated, but I'm keeping this to the bare bones, that they will look at the applicants and determine, are they qualified to be appointed? And they have to send at least 2 names, or 3, depending on whether you're reading the Constitution or the statutes, to the governor, and then the governor makes an appointment. And then, after that, the person will stand for a retention election, essentially every 6 years, although the first time is a slightly shorter period. All of the judges on this panel have gone through that process at least once. Some of us have gone through it as many as 3 different times for 3 different levels of courts. So to get to this court, you have to persuade the nominating commission or commissions for this court. The Chief Justice has a commission, and each one of the rest of us come from a specific geographic district, and there's a nominating commission for that district. In my case, for example, the 3rd Judicial District for the Supreme Court is essentially Northeast Nebraska, and I had to persuade the nominating commission for that area that I was qualified, and then had to persuade the governor that I should be appointed. And that, in essence, is how you get here.
Thank you.
Thank you very much. And I hate to cut this off, but that's pretty much a wrap. Again, thank you so much for hosting us, everybody here in Papillion. And I hope it was a learning experience for you, and it's always a learning experience for us. So thank you all very much. Doris has a question.
Pictures.
Would the court be amenable to having like 3 different pictures taken, one with the mock trial team, one with the student ambassadors, and then Carol's team of media students?
No, for security purposes, we'd never have our pictures taken. No, we'd be happy to have our pictures taken.
Could we have the student ambassadors